the record, our jury has now left the courtroom. Mr. Colvin had brought up an issue up at the bench prior to the defense opening statement that he had received a text message from family or someone associated with Mr. Jones, who had told defense counsel that they were able to hear communications at defense table on the internet, I think is what you had said.
May I clarify a little bit, Judge?
Yes, sir.
So, as I understand it, a family member of Mr. Jones has texted another family member indicating that they thought they could hear some stuff, but they couldn't quite make it out specifically. We haven't heard anything new since then, so it sounds like the actual words weren't being picked up, just that there was speaking from the defense, but nothing that was intelligible.
Okay.
So at this point, I don't have a request to make, but I do have a question. I'd like to know whether or not there's directional mics being used by the media pointed at us, or what is the situation with the microphones. I don't think we were picked up on the court's mics, but maybe I need to be worried about that instead, frankly.
I don't, Mr. Schuman is the cameraman who's here again. Are you just using the court's microphone system and tied into that, is that right?
Yes, sir.
Okay.
So
That was my understanding, and so the microphones are very sensitive. If they're pointed in your direction, they're going to be picked up, and actually it comes over the speakers as well in the courtroom, so the media doesn't have any other way of audio, picking up your audio, so.
Thank you. That actually addresses my concerns. We just need to be hyper paranoid about the court's microphone system, apparently. While, of course, recognizing you need a record of what we say. I'm not suggesting otherwise.
It will mute for you, I think, if you hold your
I have no information that our specific words are actually intelligible over the streaming. So, like I said, I have no request at this time.
All right, thank you. Anything, Mr. Rubenstein?
Not on that issue, Judge. I did have one other issue, just want to briefly discuss when the court's ready.
Okay, that's fine, thanks.
As the court is aware, I know from your reserved ruling, you had a reserved ruling on my motion to reconsider the order excluding witnesses pending a response from the defense, and that defense counsel had filed one.
Yes.
I don't know if the court had seen their response, but they offered, rather than me filing a reply, I don't know where the court is on that issue, but they had offered a jury instruction. Instruct the jury that the witness wants to answer that question, but that one of the parties is objecting to the witness answering that question. I mean, I think the way it's worded is extremely prejudicial. I don't know if the court is considering that instruction. If we can discuss it further, possibly on Monday, if that's something that you need me to address, but I don't know if that's something you're considering.
Well, I'll probably issue an order this weekend on it, quite frankly, so if we want to talk about it now, that's fine. One of the things that I've been thinking about is, I think one of the main concerns was that Ms. Jones was out of the courtroom for so many weeks. And I'm trying to remember the trial and trying to think how her being here for almost all of that testimony would prejudice the prosecution. For example, hearing the Bergfields testify, or there were just so many witnesses that Ms. Jones's part in all of this is fairly small in a way as far as the other witnesses are concerned. She has her limited information about times. And then, so that's my concern, is why is she out of the courtroom for all these weeks with the prejudice the defense has articulated? So I don't know if there's some other remedy. I've thought, well, maybe the prosecution would be agreeable to let her sit in here during some witnesses that have nothing to do with the testimony she's going to give. But you all know your case is better, and I'm trying to remember. But those are things that I'm thinking of. Why couldn't she be called earlier in the prosecution's case? Or how is the prosecution prejudiced by allowing her to be in here and hear certain things that have nothing to do with her testimony as far as I can tell? So.
And Judge, my response to that is, I think the rule going to testify to or what the, what the various differences are between this trial, I don't feel like I can answer the question to the court as to what the prejudice is, but I also feel like the court shouldn't be requiring that of us, as the rule is mandatory. The case law seems to suggest it's mandatory without, I believe they've articulated how their situation falls under those exceptions. The exceptions are very specific under the law as to parties, agents of parties, or people necessary for the presentation of evidence. Their response tried to articulate some, I guess I would describe it as a loose effort to explain why she was necessary for the presentation of their evidence, but I would say falls far short of that being a genuine explanation, to the extent that the jury might wonder whether or not she wanted to be present. It's my recollection that Mr. Colvin asked her on the stand whether or not she wanted to be present during the last trial, and brought it out to the jury that she was excluded because that's one of the rules of the court. And I don't have any problem with him doing that again. I don't have any problem with the court giving an instruction, not the one that was suggested, which I think has all sorts of prejudicial areas in it, but I think an instruction indicating that witnesses are not allowed to be there during the testimony of other witnesses, with very limited exceptions under the law. The VRA is one of them. And that's a specific legal exception, and I don't believe that Ms. Jones falls under that. And until we get to the point of her testifying, I don't know what she may.
I think that it's unfair to the defense that you can keep her out of the trial until you decide to call her to talk about the times that she's already talked about a number of times and testified about. I don't think you really you impeached her in some ways with things she couldn't remember from Investigator Martin, but otherwise it seems as though you can just wait. You could call her as the last witness in the trial and she doesn't get to be here for Mr. Jones.
Judge, I don't believe she has the right to be here. And when you asked me if it's unfair,
Okay, thanks. Was there anything else you wanted to add, Mr. Rubenstein?
again, if the court is considering the instruction, there's been a couple of very specific sentences that I think are overly prejudicial. If that's where we're going to go, I think we don't need to address that unless the court says in instructions.
Well, I don't know yet, so
Okay.
if you want to...
Sure.
I thought you were just objecting to the entire instruction, and you
Yeah,
are, but
I am.
some are particularly more objectionable to you. Is that
Well,
right?
it says,
And I'm sorry, I need to get
sure,
to it on the computer here.
as soon as you have it up, please let me know.
Okay, I have it now, thank you.
So the second sentence says, you are instructed, well, so the first sentence is, you've noticed that she's not present. The second says, you are instructed that this was due solely to the prosecution's objection to her presence in the courtroom, despite the fact that members of the Bergfeld family were allowed to remain in the courtroom. I think that sentence has no place in there. If this is a rule of evidence, the rule excluding witnesses is a rule of evidence, and we don't, under any other rule of evidence, for example, hearsay, if somebody objects to something as being hearsay, the court doesn't say, you are instructed that this witness wants to tell the and when or if witnesses are allowed to be present during the testimony of other witnesses. And then there's another reference similar. I don't really have any objection to her absence from these presence is not an indication that she does not support her husband. I have no objection to that. This next part I do. Rather, it is the result of the prosecution's deliberate decision to exclude her from this trial. I'm making a deliberate decision to exclude all witnesses from the trial so that they don't hear the evidence of the other witnesses. The court even does a balancing test on the Bergfelds as to whether or not, and as Your Honor is aware, the Bergfelds are not eye and ear witnesses to anything related to this. They don't have any information about this. Their testimony was solely about relationships and other things like that, and I made a specific effort to call them at the very beginning of the prosecution's case. But other than their rights under the Victim Rights Amendment, which is not my right and not my request that they be present, it's their request that they be present, my request is that all witnesses be excluded from the testimony of other witnesses with the exception of the advisories. And so I would object to that sentence as well. And then you may not consider her absence. I don't have any objection to the last sentence. It's just those two that explain it as somehow that this is not about the prosecution's right to a fair trial, but somehow that we're being vindictive or in some way, or that somehow sort of suggests that.
Okay, thank you. Mr. Colvin, was there further argument you'd like to make?
Real briefly, I think I've articulated this, but I just want to make sure the record's clear if I didn't articulate it sufficiently. Absolutely, the absence of moral support for Mr. Jones is a huge factor, but the prejudice is the fact that the jury sat through weeks and weeks of trial with the Bergfelds sitting directly behind the prosecution. Everyone in the room knew who the Bergfelds were. It was absolutely clear the Bergfelds were extremely both allied with prosecution, allied with law enforcement, and absolutely interested in this case. That was contrasted distinctly by the fact that Mr. Jones' wife, who prosecution has called as a witness against Mr. Jones, was not present, thereby falsely creating the impression that Ms. Bergfeld's family is interested in this case, Mr. Jones' family is not interested in this case. That is the prejudice. And so I am asking that the court, if our instruction is too aggressive, I'm asking the court at least give some instruction if Ms. Jones cannot be present in the courtroom. Thank you. I have nothing further.
Thank you. Mr. Rubenstein, anything else on this issue?
I will just note, Mr. Jones did have other family members that were present. It was just specifically Elaine Jones.
Obviously identified with Mr. Jones, because we're not going around telling the jury his niece is present, his sister is present. That is very different than having Mr. Bergfeld testify at some length about the fact that Mesa County Sheriff's Department did yeoman's work in this case. It's a marked difference.
I didn't have anything further, Your Honor.
Okay. Did anybody else have any other issues before we recess?
No, sir.
No, sir.
No. All right. Thank you. I hope you all have a good weekend. I'll see you at 9 o'clock Monday morning. We're in recess.